Happy Friday, everybody. Looks like it's another week in the books and a lot going on when it comes to litigation against Illinois' gun ban, something we've been opening the show with practically every day since it was enacted January 10th. Just a little over 3 months ago. Of course, Wednesday we had the hearing in federal court. We'll talk a little bit about that. We'll also talk about some of the latest in the state level court updates from Thomas DeVore last night about filings that they're making as amici briefs, friends of the court briefs. So let's go ahead and get right on into it. I'm Greg Bishop. Thanks for hanging out. You can follow me anywhere, Bishop on Air. Just search Twitter, Facebook, YouTube, and you'll find it. Also, if you watch live and you can't stick around the entire time, totally get it. You can check out my YouTube page for some choice and curated clips from The Daily Show. So a way for you to kind of still get what we're talking about if you can't stick around the whole time. And also check out the archives there because we've been covering this step by step from every angle, especially when it comes to the ban on semi-automatic firearms and magazines in the state of Illinois. Talking with various individuals, and we're actually going to be discussing the federal case with one of the plaintiffs in that. We'll talk with Dane Harrell later on after 7 o'clock this morning. So the federal case, obviously, focusing on the Second Amendment issues when it comes to challenging Illinois' gun and magazine ban. And some of the nuance that's really come out here deals with everything from guns that make firing easier for those with disabilities being banned to you not being able to buy certain parts to fix your own gun at home to even what the state's getting wrong when it's putting in its documents what is or is not a grenade launcher. So these arguments were pretty nuanced during Wednesday's hearing, and if you followed along on my Twitter account, you definitely caught some of that. But afterwards, I just want to revisit some of what Thomas Magg had to say. Thomas Magg's the attorney that was first to file against the state in state court, and that was transferred to federal court, where it was then lumped in with 3 other cases in the Southern District of Illinois. And in federal court, they had that hearing on Wednesday. Afterwards, Magg, he laid out some of his observations on just how exactly this is playing out in federal court.
The weak point in the defendant's arguments boils down to that they're arguing that the legislature is not bound by the Constitution. That's the exact opposite of how it really works. The Constitution controls what the legislature does. The legislature doesn't get to control what the Constitution does. I mean, the judge had obviously noticed that the state had labeled a flare gun as a grenade launcher, which there's a world of difference between a flare gun, which is a distress signal device, and a grenade launcher, which is designed to throw bombs a couple of hundred yards. And there's a world of difference between an anti-tank rifle or an artillery piece and a 50 caliber rifle. Obviously, the elderly, those with physical infirmities, require different types of firearms than a strong 19-year-old bodybuilder. Yes, I do think that that's very important. For instance, my own mother-in-law has severe arthritis. She cannot handle most modern firearms. We had to find one that she could handle with her arthritis.
So again, Thomas Magg talking about some of the nuance there, let alone the nuance of what is a semi-automatic weapon and how many rounds should be allowed in capacity of a magazine, and what is the Second Amendment and so on. But the nuance really gets down into it in the federal case. Now, again, that's challenging the law on Second Amendment grounds in federal courts, where it could go to the appeals court, it could go to the Supreme Court of the United States. So we don't know exactly when the federal judge in the Southern District is going to make a decision on a preliminary injunction that could issue statewide, blocking the law from being implemented. So that's the federal court. In state court, you've got several cases, one that's in front of the Illinois Supreme Court from Dan Calkins out of Macon County, where a judge there issued a final judgment saying that the law is unconstitutional based off of equal protections violations. That's very similar to 3 other cases that Attorney Thomas DeVore has separately in Effingham County, 2 from Effingham County, 1 in White. Those have been consolidated. In Effingham, there's about 7,000 plaintiffs or so that have temporary restraining orders, keeping them safe from the state enforcing that. Well, DeVore last night, he provided an update for his clients and for just the general public, talking about the state-level case and the challenge in front of the Illinois Supreme Court. He touched on things we've already covered from, the attorneys, the plaintiffs looking to have several judges essentially recuse themselves from hearing the case in Illinois Supreme Court because they got $1 million donation from Governor J.B. Pritzker each, plus six-figure donations from Speaker Welch, raising the question of impropriety. So DeVore touched on that. He also touched on the amicus brief that 33 state's attorneys from across the state filed supporting the Calkins position in this, but also going further to talk about Second Amendment issues, not just the equal protections issues. DeVore, he says, and we have yet to see this put on the Supreme Court's website, but DeVore says he has now filed an amicus brief with the Illinois Supreme Court on this Calkins case. And last night on his YouTube channel, he laid out some of what he has ultimately had to say about this ongoing issue of the Illinois Supreme Court case and his client's position in that case.
The brief that we filed, again, even though we're not parties to that case, we have 7,000 plus people in the Effingham County case. That's the identical case. We have an issue. We have an interest in what's going on in that case because the Macon County case, as you guys are aware, it's your case. They just copied and pasted it and filed it in Macon County. We don't need to rehash all of that. But we have an interest in the outcome of that case. And we filed it. And here's what we argued in our case. We also argued, justices, we understand that Calkins is dealing with equal protection. And I threw a little bit of equal protection in there. I couldn't help myself. You guys can read it. But I said, guess what, by the way? Just as the state's attorneys argued that you can find this law unconstitutional for any other legal reason, we are going to say the same thing. And guess what we're arguing in ours? The procedural violations under the 3 readings rule of Article 4, Section 8 of the Illinois Constitution. I bring the whole argument to them on the 3 readings rule. Do they have to follow what I'm arguing for you? No, but I'm damn well going to put it in front of them. And I all but challenge them to take that issue up right now. They want to deny it. You guys will know that they won't even consider it. But we filed it. It's like, we can still deal with that in our case too. But I'm like, you know what? We're going to put that issue in front of them right now. So they've got the Supreme Court of Illinois has 3 issues in front of it right now against this law. They've got the equal protection. They've got the Second Amendment filed by the state's attorneys, and they've got the procedural 3 readings violation brought by us. That's 3 different shots across the bow at the Supreme Court of Illinois to find this law unconstitutional. Again, that's not the best position for us to be in, the absolute best, but it's best we got right now. Okay.
So it's Tom DeVore again giving an update on his filing he says he made to the Illinois Supreme Court last night. I have yet to see that linked up to the Illinois Supreme Court. I imagine it'll be there at some point. But you've got filings back and forth that are still happening in the Illinois Supreme Court case. Again, just so people are clear, the Illinois Supreme Court is separate from the federal courts, where you've got the consolidated cases in federal court that was heard Wednesday. So one set of cases, Illinois State Court, dealing with equal protections. You heard Thomas DeVore there saying that the state's attorneys also brought up Second Amendment issues in their amicus brief, and DeVore is filed bringing up equal protections, the issue of the Second Amendment, but also now he's adding the issue of how the legislation was passed at the state legislature, an allegation of it violating the 3 readings rule, that you have to read legislation 3 days before it gets passed. The allegation is they didn't do that with this particular law. So DeVore injecting that into it. Now, it doesn't mean that the Supreme Court has to take those issues up. It's just merely something that they can consider in the Illinois Supreme Court. Again, that's separate from the federal court, where you had the challenge against the state law on the grounds of Second Amendment issues, and that was heard on Wednesday. Still not sure when the judge is going to issue a ruling in the federal courts, which could lead to a statewide preliminary injunction halting the law from being enforceable. It could be weeks still yet. It could be days. Who knows? But we'll definitely be watching that closely to see what happens with the twists and turns and all of this.